Hi, everyone. Welcome back to the Business Immigration Benchmark. I'm your host, Laura Blanares. Coming up on this episode, I'm going to break down the preliminary finding of WR's March benchmarking survey on H-1B alternatives. We fielded a survey to HR immigration and mobility professionals on what their corporate policies look like in light of H-1B lottery. So this is a timely episode here. And I'm excited to talk about the initial results of that survey. Then after that, what has become a customary feature on our podcast, my producer Finn will hop on and we'll run through a few scenarios that are inspired by real-world challenges that I've seen global mobility professionals face in regards to H-1B alternatives. But before all that, I'm going to spend just a couple of minutes talking about cost containment, given that this episode will be released April 1st, which marks the first official day when many of these new USCIS fee increases are taking effect. One brief housekeeping item. We're always looking for suggestions from HR, immigration, and global mobility professionals on what you want us to cover in these episodes, as well as questions you'd like to see us include in future benchmarking surveys. So if you'd like to influence this episode or future benchmarking surveys, feel free to send me a DM on LinkedIn. I'd love to connect and hear your thoughts. And then finally, a shameless favor to ask. If you're listening and you've got some value from this episode, I'd really appreciate if you could share it with your colleagues in the industry. And I know from talking to my clients and others in this space, as well as the surveys that we receive this year, that most HR, immigration, and global mobility professionals are learning or hearing of updates informally through their colleagues. I really want to change that by bringing formal, reliable, and wide-reaching benchmarking data to the industry. So send them our way because I really want to change the tone of the conversation to bring the conversation to this platform and answer the questions that you guys are wrestling with. So again, do share this with colleagues and do DM me with any suggestions because I believe that strong and transparent data is what helps drive efficient and effective solutions for global mobility programs. We put a lot of time, research, and thought into our episodes each week, and we'd love to grow our audience to reach folks that would find this interesting, compelling, because we not only want to help HR, global mobility professionals with their challenging issues they deal with and wrestle with every day at their organizations, but we also want to help you all grow your career. So if there are things that you're thinking about or things you're hearing in the industry, please do share. We'd love to tackle it here on the Business Immigration Benchmark. I also want to quickly plug that in next week's episode, we're going to be talking all things H-1B alternatives, but next week, I'm going to be chatting with WR's global managing partner, Audrey Lustgarten, and we're going to pick her brain on not only what are some global 2024 trends and challenges, but also it's a good reference for thinking about H-1B alternatives, because as we'll discuss within the survey, more and more companies are considering relocation for foreign nationals outside the U.S., and Audrey's just the woman to chat through that with. So tune in next week for understanding what that might look like if your organization's considering relocating your top talent abroad in light of H-1B results. Okay, so with that, I want to start by following up on an episode I did a few weeks ago on cost containment, given that as of April 1st, the new USCIS fees are dropping and taking effect. And, we're in this era of cost containment as I dove into in that previous episode. But I want to go through what, again, are the fee increases. So quick overview of the most relevant fee increases that will impact most companies. H-1Bs going from $460 for that I-129, going to be increased to $780. The L-1 used to be, if you filed it with USCIS, $460, that's going up to $1,385. O-1 used to be $460 and now it's going up to $1,055. So this is going to be really confusing for organizations to tackle. So I hope you have really good reporting with your corporate immigration counsel, because before April 1st, all non-immigrant visas filed on the form I-129 used to be the same fee. And now, as I've just described, they're all different. They're all going up. The green card, meaning the I-485, I-131, I-765 that are filed concurrently as a green card current package, they're all increasing 10% or more. Also effective April 1st, the government added this asylum program fee. So that's attaching to all filed I-129 and some I-140s. So you have to be very careful about when the asylum program fee applies to the filing, and that's an additional $600. Next year, we're going to see the H-1B cap registration. Right now, we've just completed filing those. Those entries were $10. That's going up to $215 per applicant. That's not to mention, we've already seen the premium processing fee increase from $2,500 to $2,805. That went into effect earlier this year on February 26th. And I think it's worth noting that, we've seen the premium processing fee creep up a lot because just a few years ago, we were filing premium processing at $1,500. So a pretty significant increase in just a few years here for premium processing alone. In the episode I did on cost containment, I think the best way to explain the impact of these fee increases is to give an example. And the example that I think is relevant or easy to understand is an H-1B transfer. So this is a common filing. And if you are a U.S. employer who employs more than 25 people in the U.S., you're going to be in this large organization category. And that's how USCIS is distinguishing some of the fees. So again, be mindful of your organizational size, which application you're filing, because it's a more complicated fee structure these days. But a typical company sponsoring an H-1B will have more than 25 employees. And, under the old government filing fee scheme or anything pre-April 1st of 2024, you would have paid $4,980 for the government filing fees, including premium processing, because with a transfer, you almost always are going to want to file with premium processing. Now, post-April 1st, you are now filing government filing fees of $6,185. So that's a percentage increase in fees of approximately 24.2%. So you're seeing your H-1B transfer fees go up by a significant margin alone. I also came across another good example showing the impact of the fees in a Forbes article that I read last week called "A Look at High Fees Making Hiring H-1B Visa Holders Challenging." The author of the piece is Stuart Anderson, who is a senior contributor that writes a regular column for Forbes that's usually focused on some aspect of highly skilled immigration in the U.S. He writes some really great pieces. He also leads a think tank called the National Foundation for American Policy, which does a lot of original and highly analytical research on the impact that immigration has on the economy. So I love reading his stuff. But in this specific article, Anderson lays out all of the potential fees that a company may need to pay to sponsor an H-1B employee over the course of just a few years. So if you haven't picked that one up, take a look. It's a nice summary of what's going on and how to understand the fee increases as it impacts the corporate immigration space. So the big takeaway here that I thought was worth spending just a few minutes on is that if you're an HR, immigration, or global mobility professional, cost containment is going to be and continues to be one of the biggest, if not the biggest issue for your program for the next few years. And we see that in our benchmarking data already. When we ask global mobility professionals what their biggest pain points are for 2024, consistently we're seeing cost containment come up as for programs big, small, whether the program is growing rapidly or whether the program is going through reduction in forces. So we're seeing it across the board that cost containment is the issue front of everyone's mind. So all the talk about the future of AI being the leading issue or challenge for global mobility professionals in 2024, I don't see it because that's not what I'm hearing, and that's not what you all are reporting when you complete these benchmarking surveys. Cost containment, perm processing delays, and global immigration pathways outside of the U.S. are and continue to be some of the most relevant challenges that we're hearing global mobility professionals face in this year and what I expect to be years to come. On that note, I'm actually planning on doing a whole episode on the most common pain points that are mentioned in our monthly benchmarking surveys in Q1. So if you're interested in participating in WR's benchmarking surveys, please send me a DM on LinkedIn, and I'd be happy to share it with you. All right, so that perfectly sets up our next segment, where we'll talk through the preliminary results of WR's March benchmarking survey and how immigration and mobility teams are approaching alternatives to the H-1B visa for their employees. Of course, this is a very timely topic in the weeks following the H-1B lottery. We don't yet know what the selection rate was for the lottery, but it's safe to say based on past performance, past selections, that hundreds of thousands of foreign national employees will not be selected in this year's lottery. And the most concerning of those non-selections are the people that we call last chancers, meaning they've run out or will soon run out of their underlying non-immigrant visa status. Most commonly, this is an F1 student who is running out of their F1 work authorization status. So all students are granted 1 year of post-training work authorization, known as the OPT. And then some students who graduated with qualifying STEM programs are given another 2 years. So the max work authorization that a F1 student can receive post-graduation is 3 years. And so we call the last chancers the folks that are completing their third year in light of the sort of lottery selection here. So those are our last chancers. Occasionally, a last chancer can also be someone who's maxing out on an L-1B and doesn't have the ability to extend the L-1, even if they've got an I-140 approved. So there's some specific situations. Anyway, we call those all last chancers. And so for these last chancers, unfortunately, this year's H-1B lottery may be their last or only chance to secure a continued work authorization in the U.S. And that poses a big problem, not just for the individuals to keep and maintain their life here in the U.S., but also for the companies that employ them for business continuity. And the solution to that problem falls on the shoulders of you all, the HR, immigration, and global mobility professionals, to solve that problem in this complicated web of U.S. immigration laws and restrictions. So that's why we fielded a survey this past month to understand what current approaches and policies companies have for those last chancers, for alternative ways to stay in the U.S., stay work authorized, stay employed by the company. So what policies do those organizations have in place for business continuity and to maintain that employee-employee relationship? For the survey, we began collecting responses on March 6th, and as of the time of this recording, we've received 25 qualified responses from verified HR, immigration, and global mobility professionals. Due to how busy this month was with all the changes with H-1B cap, we're continuing to field this survey, and we'll leave it open for another week or so to collect additional responses. So if you're interested in participating, again, please send me a DM on LinkedIn, and I'd be happy to share it with you. All the information you provide in the survey will not be shared with any third party, and your identity and the identity of your company will remain anonymous when we share those results. And if there are any changes to the results after these additional responses and any additional responses come in, I'll be sure to call out those changes in a future episode. So for now, I want to briefly cover and share a few of the characteristics of our current respondent pool. The average experience level of respondents is a little over 10 years of direct immigration or global mobility experience. The average program size of the respondent's company, 249 foreign nationals. Median program size, 125 foreign national employees. The range of the program size was between 5 and 1,000 plus foreign nationals. Our survey length was 12 questions and on average was completed within 6.5 minutes. So with that, let's look at the highlights from the data we collected. Highlight 1. Okay, so first question, we asked respondents, other than the H-1B, which temporary U.S. visas does your company sponsor for? Please select all that apply. The options we provided were L1, TN, O1, F1 STEM EAD, H-1B1, E3, J1, we only sponsor H-1B, I don't know, and open-ended other. 83% sponsor for L1, 100% sponsor for TN, 71% sponsor for O1, 88% sponsor or cover the fees for F1 STEM EADs, 50% sponsor for H-1B1, 67% sponsor for E3s, 42% sponsor for J1s. The rest were 0% or statistically insignificant. I think the takeaway here is that the percentage of sponsoring of the different visa classifications probably speak to size of program and honestly just the rate of those visas that I know TNs are likely the most common. And then it sort of falls in that order, like F1 being 88%, L1 being the next highest sponsored. That's probably just the incident of how common those visas are across the U.S. So that's not shocking information. The highlight 2, in the next question, we asked survey respondents, does your corporate immigration team or law firm have an established assessment process to evaluate foreign national employees for alternative U.S. visa options outside of the H-1B lottery? 3/4 of respondents said yes, so that's awesome. 17% said no, or no, but we're currently working on it. 8% said, I don't know. So I think it's great that, 75% of respondents have an assessment process, whether that's baked internally or in partnership with legal counsel. So that's great. And that for the 17% that said no, I hope all of them are no, but working on it, because it's just important that you've got the right understanding for that candidate when you're bringing them in, and that the manager, the business team knows exactly what their future is, or if there's a limited work authorization permission in this employee's future, so that everybody has just clear expectations. Highlight 3. So when we asked respondents, does your corporate immigration team or law firm assess foreign national employees for a national interest waiver or EB-1 green card sponsorship? 71% said yes, 21% said no, 8% said I don't know or other. So again, this is great. The majority of people are appropriately assessing. If you're moving into a green card, they're assessing foreign nationals for other green card pathways other than PERM, such as the national interest waiver and EB-1. Again, I know I've talked about it. The national interest waiver is super buzzy. Everybody says, you can get one. The reality is it's not going to be a fit for everybody, but it's good that the majority of companies are reviewing them and assessing to understand and make sure their foreign national employees know they've been screened, so that if they were eligible for those benefits, the company could proceed. So it's nice to know. Highlight 4, we also asked respondents prior to this year's H-1B registration period, did your company's immigration service provider or law firm provide personalized evaluations of H-1B alternatives for your last chancers for national employees? 88% yes, 12% said no. I think that's great that an overwhelming majority of these programs are getting dedicated, personalized support and consultation for these last chancers. Because again, it's probable that the company can't do much, but in the event that they can, they're being screened and given a personalized plan for all of their employees for transparency, for management of expectations. This is a good thing. Then I'll finish off here with what I think are the most interesting findings from the survey. And that's the result we saw when we asked respondents, is your company supportive of relocating employees overseas if they exhaust their F1 OPT, STEM OPT status after not being selected in the H-1B lottery? So this is like, does the company support relocating these last chancers outside of the U.S.? 83% of respondents answered yes to this question. And then just 17% split between no or I don't know. And this is a question I get a lot about, are other companies relocating their last chancers outside of the U.S.? And now we can definitively say, yeah, the majority are. I think for those that say no or I don't know, I think the challenges they're up against are the cost of relocation or the lack of global international operations. So depending on the company's size, smaller startup companies don't necessarily have established operations in Canada, in Europe, in APAC. So they don't have the ability to internally transfer them outside of the US because they have nowhere to land. I encountered and have met with some folks at Syndesis, and there's an interesting alternative there where you can park someone in Canada under Syndesis's contracting arrangement. So if you don't have global operations, you can park this employee as a contractor through this arrangement with Syndesis in Canada. And I think the benefits there are, keeping someone in the same time zone. Or if your company, Canada would be the next location where you'd want to open up operations, it would be a nice sort of entry point. So anyway, shout out to those folks there. But I do think there could still be cost concerns with that. So I think often the folks that are saying, no, we don't do international relocation, like I said, are coming up against cost or lack of, opportunity to relocate them at some sort of internal location. Okay, then as a follow-up to that question, we asked respondents, if you answered yes in the question above, what criteria must an employee meet to receive support for overseas relocation? If you answered no, what are the primary concerns that deter the company from supporting overseas relocation? So this is an open-ended question, but over 60% of responses mentioned the performance of the employee impacted whether or not the company would support an overseas relocation. So that makes a ton of sense. Companies that are able and willing to relocate talent abroad will do so if it's top talent. That makes a ton of sense. You want to retain top talent, whether that's in the U.S. or relocating them outside of the U.S. And I think an openness to support relocation I think is a post-COVID trend here. What we're seeing now is where U.S. companies will park this top talent, perhaps in Canada or another strategic location. And because of the COVID era work arrangements, companies are more tolerant for remote work opportunities to retain that talent. And I think Canada is a obvious or likely option if that company has operations there because they're in a US time zone and for better partnering and things like that. So we see that pretty often. More than ever, I think companies are more open to this. The big picture here is that I think we're seeing a higher outbound immigration pattern where because the U.S. immigration is so restrictive, because we're subject to an H-1B lottery that's been stuck at the same level since 2004, and there's clearly a demand and an appetite for top talent, companies are leveraging global operations and overseas opportunities to retain these employees. So I think if you're a global mobility professional these days, I think cross-training in global operations, cross-training in global immigration processes is going to be a big key factor for your future career because I don't see the U.S. levels of immigration changing anytime soon, especially not in an election year. And, especially with a crisis at the border, I don't think any levels of employment-based immigration will be increased until Congress solves the crisis at the border. So I think immigration is going to be really stuck for a while. We all know it's a quagmire, but as far as when we think about it just from immigration patterns sake, levels aren't going to be going up anytime soon. And I think we're going to continue to see high levels of outflow. A couple anecdotes I'll share here is when I'm on these layoff consultations, some of my clients will offer that I speak with their foreign national employees who have been impacted by a layoff. Folks who have H-1B that could, transfer to another company in the U.S. 3 times this year, I've had employees who've been laid off say like, yeah, I'm just going back to my home country. Like, I don't want to stay here anymore. And I've never, again, I've been practicing 10 years. I've dealt with different waves of layoffs. This is the first time I've seen this year alone 3 people say, yeah, no, I'm packing up and going. I'm not going to look to do a transfer. So that's definitely, to me, speaking about, an outbound movement. I think largely because of the frustration of the ability for folks to stay here with any kind of reliability with the green card lines getting longer. So interesting pattern. And, I think we're keying up a nice conversation with Audrey Lustgarten next week to get a bigger scope of what's happening in the global immigration trends for 2024. Okay, so with that, I'm going to bring on my producer, Finn, to run through a few scenarios inspired by real-world challenges that I've seen global mobility professionals face with these H-1B alternatives. We're going to change up a few details to keep the inspiration of these scenarios anonymous, but my hope is that if you're listening, at least one of these scenarios will resonate with what your program is facing, and that the suggestions I provide will offer some direction on how to solve your company's unique business problems.
All right, the first scenario is an immigration manager is tasked with finding alternative pathways for 8 last chancers who are in F1 STEM EADs. They were not selected in this year's lottery, but the company would like for them to continue working in their roles on some capacity. The managers of all 8 last chancers are really adamant about keeping these employees, regardless of the fact that they were not selected in the lottery and are coming up on expiring EADs. Fast facts about this company. It's a fintech company. This immigration manager has about 7 years of experience, is overseeing a program with about 184 national employees. The company does have global offices in Canada, Germany, and Singapore, and they are a remote first company, which is an important note here, I think. They listed their 2024 main pain points as a low selection rate in the H-1B lottery. And they're also dissatisfied with their current global immigration support. They feel like that's causing some bottlenecks for them. So Laura, the question here is, how would you consult this senior immigration manager on seeking out alternative work authorization options for the company's 8 last chancers?
Cool. So given the remote first culture of this company, I think they likely have an openness for relocation abroad. I think you only move to that scenario assuming that counsel, U.S. Immigration Counsel, in partnership with the senior immigration manager, has assessed whether there are any U.S.-based visa options Again, that's probably unlikely. Most F1 students don't have an easy ability to flip to another visa category that gives them immediate work authorization in the US. So the relocation abroad is a great option for this remote first company, assuming that they are comfortable with the costs of relocation. Now they're in Canada, Germany, and Singapore. So depending on what opportunities the business has in those locations, like can these employees move to teams that are based in one of those countries, or does the manager want to keep the employee on their team? Often the manager wants to keep the employee on their own team, and that makes Canada a nice option because they're going to be likely within the same time zone or at least a US time zone. So I think the company should think through what countries make sense for these employees and put together, Audrey will talk more about this in next week's episode, a sort of scheme or a menu of here's what options we're willing to support, and that they sort of have the pre-approved cost plan with the various options. So this is a great opportunity for a remote first company to leverage their international operations and work with global counsel to set up expectations for the manager about relocation costs, timeline, because without knowing exactly how urgent some of these max out dates in the US are, will tee up how quickly they need to be placed in Canada, Germany, or Singapore. And maybe the options are limited based on how quickly they need to move to one of those jurisdictions and whether one of those jurisdictions has a faster processing time, which Audrey can tell us more about that next week.
Cool. So just two scenarios this week. So this is the last one here. A global head of immigration and mobility is dissatisfied with their company's immigration provider following the H-1B cap lottery. And this is because their counsel failed to deliver personalized backup plans for each employee in the event that they were not selected. And that sort of came to a head because the company had a disappointing selection rate in the lottery this year. And now the head of and now the higher up of this global head of immigration and mobility is pressuring this individual to find work authorization solutions for key client-facing employees who were not selected in the lottery. So that's a bit of the background there. This is a consulting company. This global head of immigration and mobility has over 20 years of experience, so very, very experienced in the field. They have a team of 17 immigration and mobility team members worldwide, including 5 in the U.S., big program with over 950 foreign national employees in the U.S. alone. They have 25 plus offices abroad in various countries. They are an in-office only company. They don't allow for remote work as of 2024. And this global head of immigration mobility listed sort of the big pain point for their program is lack of communication with sort of their global providers and vendors and lack of communication with their internal teams globally. So, Laura, what menu of options would you give this global head of immigration and mobility to address the issue here?
I mean, this is a tough one. Let's hope for better selection rates this year. But, this is an example from last year with disappointing selection rates, and you're in a tough position. I think the first thing you have to do is prioritize the review of these max outs by the date that they're maxing out to sort of get a dedicated review assessment based on how urgent the case is. So that's the first order of business. And then it's going to be difficult. We want everybody on the call, manager, higher ups, employee, counsel, all talking to these stakeholders all at once so that they can review the options with all of the folks at the same time. I think the reality is that most of these last chancers are not going to have a quick and easy solution that the company can support. When I'm on these calls, often the only option to keep someone in the US is for the employee who's maxing out on their F1 to enroll in a new academic program, which doesn't necessarily give them immediate work authorization. The other challenge is that the company can't sponsor the F1. So they're in a tough position where the employee has the burden to figure that out. As counsel, I don't recommend which academic program they can enroll in. I just say that if you want to maintain the F status, you have to enroll in a new academic program. And if the foreign national has already received a master's, the only way that they can receive a new grant of OPT OPT EAD is to go for the PhD, is to go for another advanced degree, a higher degree. So that is an opportunity, but it doesn't necessarily mean that they're going to stay employed. These are really tough situations. That's why, I think more and more companies are exploring the relocation abroad to keep top talent. It sounds like this isn't the relocation abroad for this consulting company isn't a good fit because these consultants are likely assigned to project teams that require in-person project performance in the US. And that's just not going to happen probably for many of these last chancers because the options are very, very limited in the US. So this is a difficult case. I think the council's not going to solve the limited options within the US immigration system. But like anything, bad news is better heard upfront, earliest as possible, so that people can plan and manage expectations. And it sounds like that's the biggest issue here, was that this is catching a lot of the business team and potentially the employees by surprise. And that's a tough situation to be in. So I think what you can do is just plan for next year about confirming when these consultations and strategies are expected to be delivered to the company so that they're not in the same situation and surprised by potential gaps in talent and employees in the future. So to wrap up today, some final thoughts. I think cost containment is going to be a big issue. We're going to talk about it more here, and this won't be the last we're diving into the impacts and how programs can wrestle with cost containment efficiencies. In light of the H-1B results, I hope everybody has a great H-1B season. And if you're finding a low selection rate, TBD on the results, I think we're finding more and more companies are open to relocation abroad. So that's a great thing. And as a global immigration professional, thinking about sharpening your skills on the outbound processes and protocols, obviously can't be an expert on every country, but sort of understanding how to issue spot and making sure you have the right vendors set up globally that you trust and feel good about supporting you, I think are continuing challenges, continuing conversations for 2024, given we're seeing this outbound trend that I don't think is going away. So send your feedback, questions, and suggestions for future episodes to me via LinkedIn. I'm a LinkedIn creature these days, so if you've got any thoughts, feedback, I've been loving the feedback I've received so far. Keep it coming. We put a lot of time, research, and thought into our episodes each week, and we love hearing from the audience with your suggestions and what you're most interested in having us cover. Thanks, everyone. We'll see you next week.